Hello, everyone. Welcome to Jamaica 411. Thank you so much for joining me today. I'm your host, Michelle Stern. So, we're still looking into the Joel and Silvera murder case. And right now, I'm presently on Wireless Station Road in Stony Hill. Now, Wireless Station Road is a very interesting road because, as you know, Stony Hill is very stony, it's very hilly. So, I'm going to show you where I am, and right behind me is the complex where Melissa was killed. So any person who is on this road, and I'm going to be showing you now the various houses that are here unfinished. You can see them down in the valley, and over there is where she was killed. So this is a dead, quiet neighborhood. This is in the morning, maybe about after 10, and we're talking about night. At least that is the allegation when the incident took place. So you imagine 3 explosions rang out in the night, and you know how it got, right? You hear the first one, it's a tap, or what that? And then you listen good, because it sounds like a gunshot, but you're not sure. You listen good, and you hear another one, you hear another one, that sounds like gunshot. Now, it has puzzled me no end, and I'm sure it has been puzzling you. Why is it that there was no gunshot? Many speculating that there must be a silencer. And yes, while that is true, there is a possibility that something else may be going on. And me not tell no lie, bug me no end. Bug me, bug me, bug me. And that is why I have to come now again and look at the location and where it is the houses are in relation to the complex, right? And why it is that nobody said they heard. And then something occurred to me. And this, of course, is also in the realm of speculation. But that is what we are left with when we can't understand the evidence. When we cannot understand the evidence, we are left with no choice but to fill the void. Because you know what they say, nature abhors a vacuum. So the vacuum that is left for us is to ask the question, why no one heard the gunshot? Now remember, we're going now based upon what the prosecutor said, not upon our own thinking. And based upon what the prosecution said in that press release, Mr. Dwayne Green, Green in more ways than one, not his fault. What happened? The witnesses to what happened that night was Silvera, Melissa, the 2 children in the house. Melissa, of course, cannot testify because, she has died. And so that leaves Silvera and the 2 children. Now, the prosecutor said, extracting from the children's evidence in their statement, that Melissa, the argument started. The argument started when Silvera said he was leaving. He told both the children and the mother he was leaving that night. And it is said that it was 10:30 that night. He said he was leaving. And Melissa said, you cannot leave. Now, those words to me are essential to the case because something must have been up in the home at the time why Melissa said, you cannot leave. Why is it that he could not leave? And I think the answer to that will explain why there was this big argument that led to her death, and the prosecution and the defense attorney will have you believe that it was she who contributed to our own murder.
Good morning, miss.
Morning, sir. How you doing? Yeah, man, I'm going for your work.
Yeah, man, I'm going to go around here to go ahead and Mr. Robert.
All right, sir. You take care of yourself. All right, so that's a brethren a pass by between work. So we are to believe that the lady said something to Silvera that contributed to her death, so she caused her own death. That is what they want us to believe. But the question is, why did she say Silvera could not leave that night? What happened? Is it that somebody was sick? Or, we need to know. So that is what caused the argument. Now, the children said they were hurling expletives at them one another. Therefore, well, actually, the word of the prosecutor was that they were swearing at each other. So the children must have heard what was being said. The question is, how much of the conversation did the children hear? And that too is a crucial piece. So the problem is with this case is that there are a whole heap of unanswered questions that can be answered. You know what the song says? There are more questions than answers. Pictures in my mind that will not show. There are more questions than answers. And the more I find out, the less I know. Yes, the more I find out, the less I know. And that's Johnny Nash. So that is the point. Now, I have very important pieces of information for you in this video, and I'm going to show it to you shortly. However, we are here asking the question based upon what the statement is that the prosecutor extracted. And we have to be mindful that he is summarizing what the children said. He's taking parts of it that he thinks it's important to bring to our attention, right? Because, all the way out there, I wonder what going on. So, one of the things that he had extracted from the children's statement was where he said that they were quarreling, or words to that effect, and the adults were swearing at each other, and then daddy left. Notice what the prosecutor never said that the children said, that they heard 3 explosions. Remember them are picking them, not necessarily know what them the explosions are. They can guess, because they watch TV, I'm sure. But he never said them heard the explosions. And this has been bugging me. Not only did the children say they never heard it, apparently, but nor the neighbors, right? 3 explosions in the dead of night in a quiet neighborhood cannot have gone unnoticed unless there is an explanation for why there was no explosion, aside from the idea that, him use a silencer. And I'll tell you why. Remember, we are going based upon what the prosecutor said. We're going to take out our mind everything else that we heard out a road from anybody else. We just go by the statement. So the children said they never heard the explosion, right? Based upon the summary of the prosecutor. Right. Now, them in the house and them hear the argument. They heard when daddy left, so they were not asleep. That is what was established by what the prosecutor said. It meant one of 2 things. Either, indeed, as the speculation is, and we may have to speculate now, that him use a silencer. And since them say she was not shot where we thought she was shot, we go by where them say she shot in our left side and our right side and upon our thigh. We don't know what they saw for kill anybody instantaneously. Right? Since them say that happened, there is something else we may not have taken into consideration. The pitney them never said they hear an explosion. And if him never use a silencer, it could possibly mean, and we're speculating now, that maybe at that time the woman never died. In other words, him never shoot her at that time. So, here's what we want. We need you guys to send this video to all of these people here on Wireless Station Road, down in the valley. I will tell you what the name of them road is shortly, because we need them to recollect. At a time, then you need to forget everything you heard, whether from Mark or anybody else, as to when she died. Forget that. All of your neighbors. And what we need for you to do is to recollect. During the course of the entire night, from the Friday evening to the Saturday morning before the sun rose, did you hear any explosion? We're talking about 3 explosions during that period of time. We want to know if you had heard 3 explosions that night. If you did, then you need to contact your attorney. You're a money man, so spend a little money. You have an attorney. All big shot people have attorney, man. And even the little shot one them. Call your attorney and tell them you want to make a statement, right? The attorney will know whether the police must get the statement or the prosecutor, but the attorney can collect the statement from you and hand it over to who must get it, right? You need to tell them the approximate time or the time and how you know the time you heard those explosions. Just report that. It's very important because nobody said they heard the explosion, but maybe you did, but you were put off by the time in which them say Melissa was shot. You follow what I'm saying? Yes. So if any of you heard any explosion during the night, whether in the evening or in the early morning Saturday, call your lawyer and ask to make a statement. Now, if on the other hand you never heard the 3 explosions that night, but you heard it during the day on Friday, call your attorney too. All we need is 3 explosions. That is the evidence of when 3 explosions took place in this area. Right? Don't matter if it's night or day now, you heard them. Call your attorney and say to your attorney, you know, say, me hear 3 explosions, you know, but another during the time when them say it happened, right? In the hours, in the night, a different time. And ask the attorney to take your statement and submit it. Because, as I said, when Mark Golding put out that Melissa had died the night before, right? It may not have been the time when them say she died. In other words, if the children said that he left the house after the quarreling, then they heard no explosion. Maybe no explosion ever took place. The explosion took place maybe at a later time. You follow what I'm saying? So all you need to do is to do your civic duty, because this case needs truth. That's what the case needs more than anything is. We need to wrap up the case because we need to know what the truth is in the matter. And no matter which part it fall, the truth we want. And since we in them business, we might as cheap put out this appeal to the people in the Stony Hill area, Wireless Station, and beyond. Me soon go tell you the other road them. The people who are on Emerald Close, right? The people them leading up, the people in the apartments adjoining Melissa, the houses that are in front across the road into the valley and up as far as Wireless Station Road. You would have heard the explosion, right? Because then loud and uno neighborhood quiet and uno no used to them listening thing there. Yes. So we're putting out this appeal to you. I am currently on Wireless Drive, and Wireless Drive is the first right of Wireless Station Road, and it then come round to a dead end. I'm not show you the people in Tapa house, but these neighbors on the side that faces the valley, and I'm not sure whether it is north, south, east, or west, but these persons would have heard the shot them ring out, whether it be day or night, the Friday or the Saturday morning. So if you look at the NLA map that I have here, National Land Agency, you see the top left and that red arrow, that is Wireless Drive, and it runs to the right. of Wireless Station Road. Now, if you look to the bottom right, what you see is a little green and the purple arrow. That is Melissa's apartment. Now, Melissa's apartment is on a hill. Let's put it that way. It's on a rise. And you see where Wireless Station Road is, all the way around to Wireless Drive. All of that is on the hillside. And between where Melissa's apartment is and Wireless Station Drive, that is what I refer to as the valley area. Those properties are below Melissa's apartment, Wireless Road, and Wireless Drive. And as you can see, Wireless Drive is directly across what I call the valley, and therefore any explosions at night in that quiet neighborhood, 3 of them ought to have been heard, even as far as there. I followed Wireless Drive all the way around to a shop, and that also is on the side of the hill. So therefore, again, any gunshot rang out that night or early Saturday morning should have been heard by all of those persons living in that neighborhood. All right, so the road that the apartment is on where Melissa was killed is called Diamond Close. And immediately as you enter the complex, to the left, you have Silverstone Drive, and that goes down. Now, they would have heard the shots. There it is. I'll show you the people in place, right? And right up on top of the hill, right there, sir, is where the apartment for Melissa is. So they are directly below. Now, I spoke to a little neighbor, and had some little fella, yes, but older than me, man. And the gentleman said he was here the night. He said he was here the night. I got to take off my spectacles and chat to you. I can line up myself properly. Because I line up here. Matter of fact, I go along down a Silverstone. Along down a little further so we can chat to you in peace and quiet. So, I can't remember for looking at the damn camera. I'm looking at the camera now. So the handsome little man tell me, say, him did the night. When me ask him first of all if he follow the case. He say yes. Me say, oh, you would have to follow it because, you are used to people that get killed up here. He said, no. He said, yeah, but you're going to chat for you up here. I said, no. He said, what about the night when they said Melissa was killed? You did hear gunshot? I said, never heard that thing. Never heard that thing. So I said to him, say, you never hear 3 explosions? He said, no. Right? And he said, he was there. And it's funny. He must say, this a case is strange. And I say, yeah, I agree with you. Because 3 explosions at the night and him just down the road from it, them just behind them, the complex where Melissa was. And them not hear an explosion. And it's like a neighborhood never hear, as we already established. So the gentleman was very much awake and was at home when them said the incident took place. And he never heard any explosions that night. I said to him, what about in the morning? You hear any explosions? He said, no. You don't hear no explosion at all, not in the morning hours. Right? So we have a neighbor which is adjoining. I think that is a complex he's into, and it's adjoining the complex Melissa is in. And then him never hear any. He said he never heard any explosion that night, nor in the wee hours of the morning. So there you have it. So that was my special report. So for the first part of this video, what we're doing is making a special appeal to all the persons in the neighborhood of Diamond Court. Those persons who are on Diamond Close, Emerald Close, Silverstone Drive, Crystal Way, Napoleon Drive, Lucas Close, Wireless Station Road, Wireless Drive, and all the way around Wireless Station Road. You are the persons who, more than anybody else, would have heard the explosions anytime on that Friday or Saturday morning. Whenever it was that you heard 3 explosions, you need to report it and give a statement, because this case is very dearth of information, and so we need your help. And so this appeal goes out to the people in the neighborhood of Diamond Court. The second appeal of this video will be going out to the family of Melissa. I know you're all very upset and you may not like at all what the DPP and the court has decided with respect to the manslaughter charge. Well, you know, there is no point in crying and moping, and now is not the time to either cry or mope. Something needs to be done, and you are the ones who will have to do it for Melissa and for all of us out here that are very cut up about it as well. Now, in the statement that was put out by the prosecutor, he said something that I found very startling. He made reference to the pathologist's report about what the cause of death was. And he said that the pathologist said that she had died from gunshot wounds. Now, that's something I would expect to hear from a doctor, but not a pathologist. I would expect a pathologist going through the individual's various organs to point out to us which bullet hit where and which bullet hit where and which one of the bullets were likely to cause the death, to bring about the death. And so something is very peculiar about that, if that indeed was what the pathologist reported in his report on the autopsy he had done. And so I say to the family, please, someone, send this to the family of Melissa, Sandra Glasgow, and others. And I'm going to say to you now, if you have not yet done so, please hire a pathologist to look at the report that the government pathologist had prepared. He would have done the autopsy and prepared his report. So what we need now is an independent eye, competent people. Get them from foreign if you must. Try and get them from the common law jurisdiction. Get a very good one to come and have a look at the report, which means you're going to have to ask the prosecutor to allow your pathologist to look at the report and draw his own findings from the report that was prepared by the government pathologist. And it is important because, based upon what the prosecutor said, there might be gems. And I'll tell you in a moment why it is necessary to have these things done. Because if indeed the pathologist made that kind of statement in his report without providing the actual cause of death, then there may be something in it that you can go on and you may say, but why? Because the DPP's decision can be reversed. She can reverse her decision. But there are circumstances in which it can be done, and I will tell you what that is in a moment. You see where we're going with it? Yes. All right, so that is to the family. Now, there is the matter now of the children. Remember, there were 3 or 4 witnesses that night as to what occurred. Melissa, SILVERA, and the twin boys. They are certain witnesses. It is essential that we find out how much of that conversation the children heard. And somebody in the family, somebody that the children trust and would talk to. You need only to start the conversation and let them talk. I would suggest you don't ask them what it was that they told the police. Just let them talk. You want to know what mommy said. And when mommy said that, what did daddy say? And when him say what daddy say, did you hear what mommy say? Yes, and they tell you what did daddy say. And keep asking them, so what happened next? What happened next? What happened next? Right? Now, there are several questions that I think would be very useful that we need to find out from the children. Now, one of them was very distraught, one of the twins, and the other one seemed to be taking it in stride. Youngsters, how they are, right? And it may be useful, I don't know, if the 2 children were in the same room at the time. I would suggest that you record them. And you can clear all of this with an attorney and let them tell you best how to go about it. Whether or not they want the police to be in another room listening or what have you. But it might be excellent to record them. But I say, get legal advice. Remember, say me not an attorney, right? Me only a somebody with common sense, like you. All right. So what it is that you need to ask the children, this is what I think the children need to provide us if they're able to. The first question that I think would be helpful is, why did Melissa say Silvera should not leave that night? What was the reason? What happened? Was there somebody in the house that was sick? Don't make the suggestion to the children, Make them tell you. Me just say to you, right? Was the baby sick? What was it? There must have been something that would cause Melissa to find his leaving the house not very helpful at that time. And I tell you why. Because if a man leave a house 10:30 at night saying going to meet and he won't be home till the next morning, you expect her to be talking about you can't leave? The thing that I would expect is for her to say, oh, woman, you go. That time foolish about meeting. Wouldn't that be the conversation you would expect? Yes, but evidently that was not the conversation that Silvera was reporting. That's what I'm saying? Yes. So there is a reason why she said mustn't leave. We need to know that. Second question. Could they hear what the parents said while they were quarreling? We want to know if they heard everything that was said. Because if they heard everything that was said and the daddy say something, they're either going to be corroborating each other or they're at odds at each other. And they are also the witnesses. Follow what I'm saying? Yes. So we need to know if they could hear what the parents were saying. Now, if they could hear clearly what the parents were saying that night, then let them tell you word for word what Melissa said and word for word what the father said during the quarrel. The third question I think they should be asked is, did they hear any explosion at all that night? And if they did, can they say when they heard it? Now, the fourth question, was there a time the parents just stopped arguing or only one parent was talking? Because that is what Silvera would have us to believe in his second statement, that he was saying, not at all, and Melissa just go on and on and on and on and on until he's losing temper and do something. So, next question. How did they know that it was their father that left the house that night? How they know? What was it? Now, I'm talking to you now. I'm going to tell if I suggest it to the children, right? Was it that they heard the grill and the grill make a certain sound? Was it the door? Did he say them? Did he say to them that are gone? How they knew it was daddy that left that night? Next question is, did they hear their mother moving around after their father left? Was she still quarreling or was the place just quiet? Right? Was she moving around? Or what about sounds? Did they hear any sounds in her bedroom or anywhere in their apartment that night after daddy left? The next question is number 7. Did their father return after he left the house, but before they found their mother? That's the next question. If they said they heard no explosions when they were quarreling, did they hear any explosion that woke them up sometime after? Right? Did they go into their parents' bedroom soon after their father left? In other words, we want to know if they heard their daddy leave, they heard nothing, and they decide to get up and go and investigate. Did they go in there at all? That is, before they went to the bedroom 6 a.m. in the morning. Did they go earlier? The next question, we want the children to say what happened after their father left. So let them give you a narration of what they heard or they saw or they smell, taste, or feel happen. And the reason for this, let me explain that there are some persons who may be confusing the issue. This is not a case about what was seen happening in the bedroom. If the prosecutor was faithful in his report of what it was that Silvera said in his second statement, this was about what was heard He said Melissa said something. He never said Melissa did anything. So there was no need for anybody to witness what she did. And according to the prosecutor, SILVERA said in the second statement that it was something she said about the children that provoked him into firing a firearm in her direction. That's what he said. So this is about what was heard. If you're following me? So we want to know now from the children. Let them narrate and tell you what happened when Daddy left. Let them narrate and tell you what happened before. Let them just talk and talk and talk. Right? And you can ask questions after them finish to clarify certain things or get certain things out. To the extent that the children were the witnesses, they don't have to go to the court. Both parties can agree that their statements can be submitted, and then them can go at each other now about this and about that. And, yes, that is for them to know. Now, when I suggested earlier that the children should be asked when the father left the house if he had returned, it was a very important reason why I said we would like to know that from the children. And that is because Fitzbailey, very excellent policeman, and I believe his partner was Mr. Spence. Very excellent investigation they did, I have to say, based upon what we heard was gathered enough to make the man so frightened that he want now to plead to manslaughter. Now, Fitzbailey would have checked the cameras on Constant Spring Road and wherever else along the way we have cameras to see when SILVERA passed. So they would have been able to confirm what he said and what the children said was the time of night when he left. And of course, they would be looking at the camera to see if he ever returned. Now, if he did return, then how would the police have missed all of that? Well, one possibility is that wherever he spent the night, that particular night, he could have borrowed a Smaddy car and returned to the house. I'm sure Fitzbailey look at that too. It is also possible that he may have borrowed a friend's car, and in that event, the friend, if you know him borrow your vehicle that night, he might have tell you him had to go home for some reason or the other and him car pop down. He might have tell you something. And he borrow your car, your conscience may not abide you, especially if you never report it to the police. But if SILVERA borrow your car that night or early morning for one reason or another, and you not send out to the police yet, you need to go and make a report. Matter of fact, get your lawyer tell you how you can do it, and you do your statement and let them send you over to the prosecutors. Otherwise, your conscience is going to kill you for the rest of your life. And that may be a very, very long time. And you will have to decide if that is something that you want for yourself. Should the children say something that contradicts what SILVERA said in the statement as far as we know, that would also be cause the prosecutor to reverse her acceptance of SILVERA's plea to manslaughter. You understand me? Yes. So it's important that we get that information now. So the family, persons who have charge of the children, whoever the children trust to tell, because it is quite possible that the explosions took place, but the children, for whatever reason, just block it out. Or they just did mention it because they don't know who these people questioning them are, and they probably want to put that in trouble. We don't know. But let them talk to somebody that they trust. They may tell them more than they would have told a stranger. You see what I'm saying? Yes. For the family, Melissa's family, the pathologist, we want the pathologist to look out for certain specific things in their report. In examining the government pathologist report, we want them to look for the possibility of death by asphyxiation. Check to see whether or not the toxicology report was done, and to see whether or not the pathologist had provided, in their view, an estimated time of death and a cause of death, and anything else that may be gleaned
from the pathologist's report. That is what you want the pathologist to do for you, and then create their own report and hand it over to the DPP, and of course, let them make of it what they will. Now, the reason why I suggested that they look for the possibility of asphyxiation, which means suffocation, is that it is also very strange that for Melissa getting shot in her left side and her right side and in her thigh, that she never bawl out. I know, yes, man, she might be a little stush, but she must have been feeling pain before she died. Did she bawl out? Did she cry out? Or did she do the Jamaican style murder? Murder? Hmm? Did she see him with a gun and say, "Where do with the gun? Put it down"? What did she do? It seemed as if nothing was done. You see what I'm saying? And therefore, I wonder if something, not in a something, with respect to how it was that he managed to kill her. So look for the possibility of asphyxiation. Good. Now, in case the neighbors or maybe the family may be saying to themselves, what is the point in all of this? It already gone to the court system. The Chief Justice is about to make his ruling on March 6th, and the prosecution and the court already accept Silvera's plea. What is the point of it all? Well, I'm here to tell you all that everything, it seems to me, I'm not a lawyer, but when we look on some of them laws, when I look on some of them laws, no matter how them say I saw it for go, there is always exception. And when it comes to the matter of the DPP accepting a plea of guilty to a lesser charge, it can be reversed. Now the question is, what would cause the DPP, or what would oblige a director of public prosecution to withdraw their acceptance of a guilty plea to a lesser charge? Let's have a look. So here is a question that I had asked AI. Can a DPP, where there is no plea agreement, withdraw acceptance of a plea of not guilty to murder but guilty to manslaughter, and in what circumstances? Their response, and they are getting this information from dpp.gov.jm, that's the DPP's website. It says yes. Yes, you heard me right. It said yes. The DPP can withdraw her acceptance of the guilty plea to manslaughter. She can do so. And in what circumstances? Let's read on. It says, yes, based on Jamaican legal principles and common law, a director of public prosecutions can withdraw acceptance of a plea of not guilty to murder, but guilty to manslaughter, even without a formal plea agreement, provided the court has not yet passed sentence. And remember, the court will be passing sentence on March 6th. So the DPP can withdraw her acceptance as long as the judge not passed sentence yet. You hear me? Yes. Now, in what circumstances? It says the DPP exercises this power through a mechanism called nolle prosequi. I hope I pronounce it right. So, what is nolle prosequi? It says a formal notice of abandonment by a plaintiff or prosecutor of all or part of a suit or action. So, in this case, it's a DPP we're dealing with. So in the case of the DPP, the nolle prosequi means that they are going to either abandon the whole case or only a portion of it. And it is done by formal notice, that is to the court. Yes, nolle prosequi, which stops the current proceedings, allowing the DPP to re-indict the accused for the original charge of murder. So that is how she would have gone about it if she's mindful to withdraw. But then again, what could have made she change her mind? That is what you want to know. Well, it says here that the source of the information is dpp.gov.jm. So make we go along over there, hear what them talking about. So let's see if we can get confirmation from the DPP's website. Now, this is some serious fine print. So let me see if we can read it for you as usual. It says the power to discontinue criminal proceedings In exercising his power to discontinue proceedings, the DPP enters what is called a nolle prosequi. This power arises under Section 94(3)(c) of the Constitution, that is of Jamaica, and Section 4 of the Criminal Justice Administration Act. Section 4 of the Criminal Justice Administration Act prescribes that at any stage before the court renders judgment, the DPP may discontinue criminal proceedings in any court by entering a nolle prosequi. He may do so by stating in open court where the proceedings are pending or by informing the clerk of the courts in writing that the Crown does not intend to continue such proceedings. So she don't have to wait till March 6th to make the announcement. She can write to the clerk of the court and tell them say she don't intend to continue with this particular proceedings. Thereupon the proceedings shall be at an end, and on receipt of such notice the accused person shall at once be discharged in respect of the charge for which the nolle prosequi is entered. So in this case, it would have been to the lesser charge of guilty by manslaughter. Because remember, she had accepted it. I imagine that is what that is saying there. The entering of a nolle prosequi by the DPP is not an acquittal of the charges being tried, and the DPP has the power to bring back or re-indict the matter. A nolle prosequi can be entered even though the accused person has pleaded guilty to a lesser charge on the indictment. For example, pleading guilty to manslaughter instead of murder, as long as the court has not yet passed sentence. So that is the confirmation. And then them start to tell you about one case, R versus Lloyd L. Richards, which looked like it's a local case. And it had gone all the way to the Privy Council. But before it gets to the Privy Council, it was at the Court of Appeal, and it appears as though Mr. Richards decided to appeal the decision of the lower court on the grounds that it says here, the ground pursued was that the prosecution on the second indictment was in contravention of Section 28 of the Constitution, which is saying that you can't try a person twice for the same offense. Now listen to what the Court of Appeal had said in dismissing the appeal, that the DPP may exercise his powers of discontinuance up to the point before sentence is passed in a criminal case. The judicial determination comes at the point where the person is either acquitted and discharged or convicted and sentenced. That is now after the jury made a decision and the judge sentenced them. Right? At that point, you can't come talk about you're going to nolle prosequi. Got the case done. You follow? So they went on to say the nolle prosequi was properly entered by the DPP, it having been entered before the judge passed sentence. So that is the key. The second point that the court made was that a plea of guilty, not followed by a sentence of the court, does not constitute a conviction. The plea of guilty is no more than a solemn confession of the ingredients of the crime alleged. The nolle prosequi was properly entered, and the DPP needed no further authorization to indict the accused man and commence proceedings de novo. And that is Latin, and it means start afresh, start over. So what the Constitution allows is that if the prosecution, in making a determination to prosecute, decide to indict on some charges and find out later that maybe those charges were not the correct one, or further evidence came that would invite them to, charge them for something else, then they can stop the proceedings with a nolle prosequi and then re-indict the person for some other charges that the prosecution deems appropriate to the crime that was committed, not the ones that they had proceeded on in the beginning. You follow? And we're going to get into the circumstances now in which the prosecution may determine that they need to enter a nolle prosequi and go back to the original indictment of murder. So let us now take a look. So the million-dollar question, what are the circumstances for the DPP's withdrawal? It says, the DPP can withdraw acceptance of the plea under the following circumstances. What plea? The guilty plea to the lesser charge of manslaughter. So what now would be the circumstances for the DPP to take it back and say she's not accepting the plea after all? Well, here we go. So before sentencing, the plea of guilty to manslaughter is not considered final until the judge has passed sentence. You heard that? So his having pleaded guilty to manslaughter is not the final of it. It is final when the judge passed sentence on March 6th. Up until that point, the DPP can enter a nolle prosequi to halt proceedings and reinstitute the murder charge. But then, what would enable her to do so? Well, let's read on. Another circumstance in which the DPP may withdraw her acceptance of the guilty plea to manslaughter, it says here discovery of new evidence. If new evidence emerges after the manslaughter plea was accepted that suggests the killing was premeditated or premeditated intent existed, the DPP may withdraw acceptance to pursue a murder conviction. And I suppose she will go the route of the nolle prosequi. They never said, but I do believe this is my understanding of what I'm talking about. So if new evidence were to emerge that suggested that this was not manslaughter but murder, then she had no choice but to withdraw the acceptance and pursue the murder conviction. That's what it is saying. And again, I'm appealing to the family. If you have not yet done so, get your own pathologist to look at the report of that government pathologist that did the autopsy on Melissa and see if they came to the same conclusions that he came to. You follow? If there is new evidence to be gleaned from that pathologist's report, this may be the grounds on which the prosecution may withdraw her acceptance of that manslaughter plea, particularly if the opinion of your pathologist, based upon what he's reading from what the government pathologist found, was that premeditation or premeditated intent existed, or for the persons who may be speaking to the children and may glean some additional information that they may not have said before because they were speaking to strangers. They may also unearth evidence, new evidence, that the prosecution will have to take into consideration, as well as the children may provide information that contradicts what it is that SILVERA said. Remember, two of them, him one, and plus them young. So this is why I say to you all, including the neighbors, please, if any of you heard any explosion in the night or the early morning, contact your lawyers and the lawyers will tell you what to do, because we'll be talking about new evidence that the prosecution never had before. Then there's a matter of what they call mistaken belief or inappropriate plea. If it is determined that the plea was entered based on a mistake of law, or if the court determines that the plea of guilty to the lesser charge should not have been accepted, the DPP can move to retry the accused. Now, I'm not sure what this is about, but you have attorneys and uno very bright and uno go to school, go study for these things. Uno can tell us what all them sitting them mean, and we appreciate it greatly. Now, you remember me saying, perhaps on Natalie's program, JPU, that it is possible that the DPP had asked the young fellow, Mr. Green, Mr. Dwayne Green, to look in the files and see whether or not there was anything in terms of evidence that they could use to refute SILVERA's statement, and he may have come back and said no. Now, here is what they are saying is another grounds for which the DPP may withdraw her acceptance. A review of initial decision. The DPP is authorized to review the police docket, and if they find the previous decision to accept manslaughter plea was made in error or was not in the interest of justice, they can reverse it. So she can go back to the file just to make sure she's making the right decision and look over the evidence of the police docket, the case. And having looked over the case and the statements and all the evidence, the pathologist report, she might find something in there that they may have overlooked, and then they realize now that when they accepted the manslaughter plea, it was in error. In those circumstances, she can reverse her decision. You follow? Yes. In essence, in essence, there are two main circumstances in which the DPP may be obliged to withdraw her acceptance of the guilty plea to manslaughter. The first is new evidence, the discovery of new evidence. That's the first. And the second one is her going over the file just to make sure that she didn't make a mistake, and she dot her I's and she cross her T's. And in the review of the police file, she may find something that suggested that accepting the plea was a mistake in that circumstance. And in the interest of justice, she may reverse her decision. You get it? Yes. So this is the reason why I started out the way I started this video, asking the people in the general area of Diamond Court, as far as Wireless Station Drive, Wireless Station Road, if you heard the explosion, report it. And I asked the family to do two things for us. Take the little boys, if they are up to it now, and ask them some questions. And we gave you the questions we think should be asked. And secondly, get yourself a pathologist if you have not yet done so, and have them look over the pathologist report. We don't have the body, but you have the report, and he may well be able to discover something there that may have been overlooked, or look at the findings and come to very different conclusions than the pathologist, which would then now oblige the prosecutor if it suggests that it is premeditated and not manslaughter, as the defense is trying to claim. And then in those circumstances, the DPP will reverse her decision to accept the plea and put in a nolle prosequi to enable her to re-indict Silvera on the murder charge that she had indicted him on in the first place. Now, as to whether the DPP is mindful to do any such thing, whatever the law says is another matter. So, what if you go through all of that trouble, spend up your money, and then when you attempt to submit your statement to the DPP, she refused to hear because, she might have feel the case done, or she just don't have no interest because she want the win under her belt and she don't care how she get it. Even if lies must be read into the court record, what would happen then? Well, she would have made a decision, and therefore that decision may be subject to what is known as judicial review. And your lawyer would have to advise you as to whether him think Uno could win. So if the DPP refused to allow access to the pathologist's report, or she refused to accept the statements introducing new evidence, and the court grant you the judicial review, then one of the things I think would happen is that the court may decide to stop the Chief Justice from making his ruling on the sentencing on March 6th until they make for them decision. You follow? So I don't know me assessor. The lawyers them know better than me. But just in case I put any ideas into your head and you wonder if the judicial review can be used to appeal the decision of the DPP to accept the plea to the lesser charge, I don't think so. It won't work in that case. You can ask your lawyer, man. Come in a lawyer. Ask your lawyer, but me not think so, because it is in their discretion. And remember, say the DPP under the Constitution cannot be directed as to how she should rule. It's fair discretion. Yes. Well, folks, that's it for me today. And you see what I tell you? If I don't ask you from the beginning to please give the video a thumbs up, me might remember. So if you reach this far, please give the video a thumbs up and share, share, share. Until next time, take very good care of yourselves and walk good.